Law of torts. Definition of tort. Some of the important definitions, which throw light on the nature of tort, are follows. As per Salmond, a tort is a civil wrong for which the remedy is an action for damages, and which is not exclusively the breach of contract or the breach of trust or breach of merely equitable obligation. As per Winfield, tortious liability arises from the breach of a duty primarily fixed the law. This duty is towards the persons generally, and its breach is redressable by an action for unliquidated damages. As per Clark and Linsell, tort is a wrong independent of contract for which the appropriate remedy is a common law action. As per Fraser, a tort is an infringement of right in rent of a private individual giving a right of compensation at the suit of injured party. As per Section 2, M, the Limitation Act, 1963, tort means a civil wrong which is not exclusively a breach of contract or breach of trust. Shortcomings of Winfield's definition. In framing this definition, Winfield is not seeking to indicate what conduct is, and what is not sufficient to involve a person in tortious liability, to distinguish from certain other branches of law. The phrase duty towards persons generally is not adequate to include duties arising from special relationships like doctor and patient, etc., and to exclude duties arising between guardian and ward or trustee and beneficiary, etc., which fall outside the ambit of law of tort. It is not necessary and distinctive remedy for damages, as the peculiar and distinctive remedy for a tort or breach of duty is fixed by the law and not by the contract, because such damages may be claimed for a breach of trust. The phrase liability arises from the breach of duty may be true at an earlier stage of development of law of tort, but it is not applicable or appropriate to an important category of liability at the present day, for example, vicarious liability of a master for his servant's tort. Thus, the tort can be defined as a civil wrong which is redressable by an action for unliquidated damages, and which is other than a mere breach of contract or breach of trust. An analysis of the various definitions of tort reveal number of elements which can be laid down as tort is a civil wrong. Such civil wrong is other than a mere breach of trust or contract. The remedy for such civil wrong lies in an action for unliquidated damages. The detailed discussion is as follows. Tort is a civil wrong. Wrong can be civil or criminal. Tort belongs to the category of civil wrongs. In the case of a civil wrong, the injured party institutes civil proceedings against the wrongdoer, and the remedy is damages. The injured party is compensated by the defendant for the injury caused to him by another party. Whereas in the case of a criminal wrong, the state brought criminal proceedings against the accused, and the remedy is not compensation. Punishment is provided to the wrongdoer. In a case where the act results in both civil as well as criminal wrong, then both the civil and criminal remedies would concurrently be available. Tort is other than breach of contract or breach of trust. In order to determine whether the wrong is tort or not, the following steps are to be followed. Whether the wrong is civil or criminal. If it is civil wrong, it has to be further seen that whether it belongs to another recognized category of the civil wrongs, such as breach of contract or breach of trust. It is only when the wrong does not belong to any other category of the wrong, that is breach of contract or trust, it is tort, and if the wrong is breach of contract or trust, it is not a tort. However, if the act involves two or more civil wrongs, one of which may be a tort, in such a case, injured party can either claim damages under law of torts or under other breach of civil wrong, for example, breach of contract, but cannot claim damages twice. Tort is redressable by action for unliquidated damages. Damages is the most important remedy for a tort. After the commission of the wrong, it is not possible to undo the harm which has already been caused, but it is the money compensation which can be awarded to the injured party. For example, if there is attack on the reputation of the person, there is nothing which can restore his lost reputation, but money compensation equivalent to harm can be paid to the injured. Unliquidated damages means when the compensation has not been determined previously or agreed by the parties, but it is left to the direction of the court. These are the unliquidated damages which distinguish tort from breach of contract or breach of trust, in which damages may be liquidated, that is, previously determined or agreed to by the parties. The definition given by the Salmon fails to underline the essential characteristics of tortious acts. According to this definition, tort is a wrong, but it does not explain what is wrong, and what kinds of wrong explaining jural features of tort. Moreover, the expression, civil wrong, itself requires explanation. The definition is more informative, but this is also not perfect. Proof of negligence residential ipso loquitur. At the end, the important points related to this maxim can be summarized as follows. 1. By applying this maxim, the burden of proof is shifted from the plaintiff to the defendant. Instead of the plaintiff proving negligence, the defendant is required to disprove it. The maxim is not a rule or law. It is a rule of evidence benefiting the plaintiff by not requiring him to prove negligence. 2. The maxim applies when 1. The injurious agency was under the management or control of the defendant, and 2. The accident is such as in the ordinary course of things does not happen if those who have the management use proper care. 3. The rule that it is for the plaintiff to prove negligence is in some cases of considerable hardship to the plaintiff, because it may be that the true cause of the accident lies solely within the knowledge of the defendant who caused it. The plaintiff can prove the accident, but he cannot prove how it happened so as to show its origin in the negligence of the defendant. The hardship is avoided to considerable extent by the maxim. 4. The rule of Rylands versus Fletcher is not an illustration of the principle of residential ipso loquitur. The liability arising out of the principle can be repelled by proof that the defendant was not negligent, whereas under the Rylands rule it is not defense to say that defendant took every possible precaution to prevent the escape of the injurious thing. 5. The principle of residential ipso loquitur has no application where the circumstances in which the accident has taken place indicate that there must have been negligence, but do not indicate as to who was negligent, or when the accident is capable of two explanations. Also, the maxim does not apply when the facts are sufficiently known. 6. Residential ipso loquitur is a common-sense approach, not limited by technical rules, to the assessment of the effect of evidence in certain circumstances. It means that a plaintiff prima facie establishes negligence where 1. It is not possible for him to prove precisely what was the relevant act or omission which began the events leading to the accident, but 2. On the evidence as it stands, in the absence of any evidence from the defendant, it is more likely that the effective cause of accident was some act or omission of the defendant. Nervous shock. This branch of law of tort is of the recent origin. This is testified by the fact as far as 1888, the Privy Council in Victorian Railway Commissioners versus Coultas did not recognize injury caused by a shock sustained through the medium of eye or ear without direct contact. This view was, however, rejected, and an action for nervous shock was recognized, but with the limitation that the shock must arise from a reasonable fear of immediate personal injury to oneself. As in Burhill versus Young, Lord Macmillan observed in this regard, the crude view that the law should take cognizance only of physical injury resulting from actual impact has been discarded, and it is now well recognized that an action will lie for injury by shock sustained through the medium of the eye or ear without direct contact. Under the cases of nervous shock, the plaintiff has to prove the following things. 1. Necessary chain of causation between nervous shock and the death or injury of one or more parties caused by the defendant's wrongful act. 2. Plaintiff is required to prove shock caused to him by seeing or hearing something. Physical injury is not necessary. 3. Close relationship of love and affection of plaintiff with the primary victim is necessary to be shown, and also that his proximity to the accident was sufficiently close in time and space. However, it has been held that the primary victim need not be a near relative of the plaintiff. Thus, a man who came up on a scene of serious accident for acting as a rescuer when suffered a nervous shock was allowed to claim the damages. Chadwick versus British Transport Corporation. Also, where a crane driver, the plaintiff, suffered a nervous shock when he saw that by the breaking of a rope of crane, its load fell into the hold of a ship where some men were at work, was allowed damages when the rope had broken due to the negligence of the defendants, Dooley versus Camel Laird and Company. Where the plaintiff suffered nervous shock when disaster at a football match was televised live and in news bulletins, but without depicting the suffering or dying of recognizable individuals, were held not entitled to damages, a Luke's case. 4. Damages for nervous shock were not limited to psychiatric damage resulting from witnessing personal injury, but could be recovered where the plaintiff witnessed destruction of his property caused by the defendant's wrongful act. Atia versus British Gas Pick. Remoteness of damages. Intervening act or events, novus actus interveniens. Damage resulting to the plaintiff after the chain of causation set in motion by the defendant's wrongful act is snapped is too remote, and does not qualify for award of damages against the defendant. The proposition so stated is simple, but the difficulty lies in formulating the principles as to when an act or event breaks the chain of causation. The snapping of the chain of causation may be caused either by a human action or a natural event. As regards human action, two principles are settled. One, that human action does not per se sever the connected sequence of acts. In other words, the mere fact that human action intervenes does not prevent the sufferer from saying that injury which is due to that human action as one of the elements in the sequence is recoverable from the original wrongdoer. And secondly, that to break the chain of causation it must be shown that there is something ultroneous, something unwarrantable, a new cause, which disturbs the sequence of events, something which can be described as either unreasonable or extraneous or extrinsic. If there is a duty to avoid risk to children, their unexpected behavior does not break the chain of causation, for their ingenuity in finding unexpected ways of doing mischief to themselves and others should never be underestimated. Rescue cases illustrate the principle that a reasonable act done by a person in consequence of the wrongful act of the defendant does not constitute novus actus breaking the chain of causation. It is reasonably foreseeable that if the defendant's wrongful act has put a person in danger of death or personal injury, some other person may come forward to effect a rescue even by exposing himself to the same risk whether or not the person endangered is one to whom he owes a duty to protect or is a mere stranger. The rescuer can, therefore, claim damages from the defendant for injuries suffered by him in effecting a rescue unless his act was a foolhardy act or wholly unreasonable. Where the novus actus is caused by an irresponsible actor, it does not break the chain of causation. Anyone who invites or gives opportunity to mischievous children to do a dangerous thing cannot escape liability on the ground that he did not do the wrong. Recklessness of a third party, as distinguished from his mere negligence, may break the chain of causation and constitute novus actus interveniens. A car broke down at night in fog on dual carriageway. The driver of the car was negligent in leaving the car on the carriageway instead of moving the car onto the verge. A lorry driven not merely negligently but recklessly collided with the stationary car and then went out of control. The lorry ended up overturned on the opposite carriageway. This would not have happened but for the reckless driving. Two other cars collided with the overturned lorry. It was held that the lorry driver's reckless driving broke the chain of causation, and it was the sole cause of the accident on opposite carriageway. In Simmons v. British Steel Pick, Lord Rogers summarized the principles involved in considering the question of remoteness of damage. The summary reads, "These authorities suggest that, once liability is established, any question of the remoteness of damage is to be approached along the following lines, which may, of course, be open to refinement and development. 1. The starting point is that a defender is not liable for a consequence of a kind which is not reasonably foreseeable. 2. While a defender is not liable for damage that was not reasonably foreseeable, it does not follow that he is liable for all damage that was reasonably foreseeable. Depending on the circumstances, the defender may not be liable for damage caused by a novice actus interveniens or unreasonable conduct on the part of the pursuer, even if it was reasonably foreseeable. 3. Subject to the qualification in 2. If the pursuer's injury is of a kind that was foreseeable, the defender is liable, even if the damage is greater in extent than was foreseeable or it was caused in a way that could not have been foreseen. 4. The defender must take his victim as he finds him. 5. Subject again to the qualification in 2. Where personal injury to the pursuer was reasonably foreseeable, the defender is liable for any personal injury, whether physical or psychiatric, which the pursuer suffers as a result of his wrongdoing. Distinction between injurious sine damnum and damnum sine injuria. First, on the basis of meaning. Injurious sine damnum means violation of a legal right without actual loss or damages, whereas damnum sine injuria means actual or substantial damages without infringement of a legal right. Second, on the basis of action. Injurious sine damnum is always actionable, whereas damnum sine injuria is never actionable. Third, on the basis of nature of wrong. Injurious sine damnum contemplates legal wrongs where there is a remedy, whereas damnum sine injuria contemplates only moral wrongs without any remedy. Fourth, on the basis of act of defendant. In injurious sine damnum, defendant acts illegally to violate legal right of the plaintiff, whereas in damnum sine injuria defendant acts legally, and thereby causes harm to the plaintiff. Crime. Distinction between tort and crime. Tort differs both in principle and procedure from a crime, and there are basic differences between a tort and a crime which are as follows. First, on the basis of nature of wrong. Tort is a private wrong. Private wrong is the infringement of civil right of an individual. It is comparatively less serious and labeled as civil wrong, whereas crime is a public wrong. Public wrong is a violation or breach of rights and duties which affect the community as a whole. It is a more serious wrong. Second, on the basis of nature of remedy. The remedy in law of tort is damages, whereas the remedy in crime is punishment. Third, on the basis of parties to suits. In case of tort, the suit is filed by injured or aggrieved party, whereas in case of crime, the complaint is filed in the name of state. Fourth, on the basis of withdrawal of suits. In case of tort, the suit can be withdrawn at any time and compromise can be done with wrongdoer, whereas in case of crime, the complaint cannot be withdrawn except in certain circumstances. Fifth, on the basis of codification. There is no codification in law of torts, whereas the criminal law is codified. Sixth, on the basis of bar of limitation. There is bar of limitation of prosecution in law of torts, whereas there is no bar of limitation of prosecution in crime. Seventh, on the basis of survival of action. In case of death of tortfeasor, his legal representative can be sued except when the tort is defamation, personal injury not causing a death, whereas in case of death of offender, the suit is put to an end. Eighth, on the basis of application of law. There is no separate statute deals with tort. Tort is based on judicial decisions, whereas the crimes are dealt in Indian Penal Code, 1860. Ninth, on the basis of intention. In tort, intention is important but not in all cases. For example, in cases of negligence, whereas in crime, intention is the crux of the offense. Despite of these differences, the injunction may be granted in tort as well as in crime. There are various wrongs which fall under law of torts as well as under criminal law, for example, assault, defamation, negligence, nuisance, and conspiracy. Distinction between tort and breach of contract. First, on the basis of fixation of duty. In tort, the duty is fixed by the law itself, whereas in contract, the duty is fixed by the party themselves. Second, on the basis of attribution of duty. In tort, the duty is towards every person of the community or society, whereas in contract, the duty is towards specific person or persons. Third, on the basis of violation of rights. A tort is a violation of a right in rem, that is, a right vested in some determinate person and available against the world at large, whereas a breach of contract is an infringement of a right in personam, that is, of a right available only against some determinate person or party. Fourth, on the basis of need of privity. In an action for tort, no privity is needed or is required to be proved, whereas in a breach of contract, privity between the parties must be proved. Fifth, on the basis of motive. In tort, motive is often taken into account, whereas in breach of contract motive is not relevant. Sixth, on the basis of damages. In tort, measure of damages is different in different circumstances, which may be nominal or exemplary, whereas in breach of contract, damages are awarded in the form of compensation for pecuniary loss suffered. Seventh, on the basis of suit by third party. A third party can sue for tort even though there was no contract between the person causing injury and the person injured, whereas a third party to a contract cannot sue for breach of contract except in some exceptional cases. Eighth, on the basis of intention. Intention is sometimes taken into consideration, whereas intention, in case of breach of contract, is of no relevance. Ninth, on the basis of concern. Law of tort is concerned with losses, whereas contract law is concerned with promises. 10th, on the basis of period of limitations. Limitation begins to run from the date when damages occurs, whereas limitation commences when the breach of obligation takes place. Distinction between tort and breach of trust. First, on the basis of damages. Damages in a tort are unliquidated, whereas damages in breach of trust are liquidated. Second, on the basis of origin. Law of torts has its origin as part of common law, whereas breach of trust could be redressed in the court of chancery. Third, on the basis of law of property. Law of tort is not regarded as a division of the law of property, whereas law of trust can be and is regarded as a division of the law of property. Distinction between tort and quasi-contract. When a person gains some advantage or benefit to which some other person was entitled to, or by such advantage another person suffers an undue loss, the law may compel the former to compensate the latter in respect of advantage so gained, even though there is no such contract. The law of quasi-contracts covers such obligations. First, on the basis of damages. A claim for damages under law of tort is always for an unliquidated sum of money, whereas a claim for damages is for liquidated sum of money. Second, on the basis of attribution of duty. Under law of torts, the duty is towards persons generally, whereas in a quasi-contract, the duty is always towards a particular person. The common point between tort and quasi-contract is that the duty in each case is imposed by the law. However, in certain cases, where a tort has been committed, the injured party has a choice of not bringing an action for damages in tort, but of suing the wrongdoer in quasi-contract to recover the value of the benefit obtained by the wrongdoer. When the injured party elects to sue in quasi-contract instead of tort, he is said to have waived the tort. Motive and malice in law of torts. Difference between motive and intention. Motive is the ultimate object with which an act is done, while intention is the immediate purpose. For example, where a person rescues a girl from vagabonds, the intention of the person is to save her. Still, the motive with which he might have done the act may be to seduce the girl. Exceptions. There are certain categories of torts where malice may be an essential element and, therefore, relevant for purpose of determining liability. In cases of deceit, malicious prosecution, injurious falsehood, and defamation, where defense of privilege or fair comment is available. The defense of qualified privilege is only available if the publication was made in good faith. 2. In cases of conspiracy, interference with trade or contractual relations. 3. In cases of nuisance, causing a personal discomfort by an unlawful motive may turn an otherwise lawful act into nuisance. 3. Malice. Malice is usually classified into two divisions: malice in fact, express or actual malice, or malice in fact means an act done with ill will towards an individual. It is, therefore, what is known as malice in the ordinary or popular sense, that is, ill will, hatred, enmity against a person. But implied malice means a wrongful act done intentionally without any just cause or excuse. B. Malice in law. Malice in law or legal malice is a term which is practically superfluous, as in law every tortious act is impliedly malicious on account of its being a legally wrongful act. The words malice in law signifies either 1. The intentional doing of a wrongful act without just cause or excuse, or 2. An action determined by an improper motive. To act maliciously means sometimes to do the act intentionally, while at other times it means to do the act from some wrong and improper motive of which the law disapproves. The distinction between malice in fact and malice in law is that A. Express malice, or malice in fact, is an act done with ill will towards an individual. Malice in law means an act done wrongfully and without reasonable and probable cause, and not, as in common parlance, an act dictated by angry feeling or vindictive motive. In order to constitute legal malice, the act done must be wrongful. B. Malice in fact depends upon motive. Malice in law depends upon knowledge. C. Malice in fact means will or any improper motive against a person, but in its legal sense, that is, malice in law means the concurrence of the mind with a wrongful act done without just cause or excuse. Defenses against tortious liability. Under certain conditions, an act ceases to be wrongful, although in absence of those conditions the same act would amount to be a wrong. Under such conditions, the act is said to be justified or excused. These conditions which excuse or justify an act which would, otherwise, have been a tort may be divided into two categories. First, those conditions which excuse or justify some specific tort, but do not excuse or justify torts generally. For example, truth and fair comment are defenses available for the tort of defamation only. Second, those conditions which are applicable to all torts equally. For example, defense of consent can excuse any tort. Thus, the second category covers those rules of immunity which limit the rules of liability in general and are called general exceptions. These general exceptions, or conditions, or justification of torts are 1. Consent or leave and license. Valenti non fit injuria. 2. Act of God. 3. Inevitable accident. 4. Necessity. 5. Private defense. 6. Acts causing slight harm. 7. Statutory authority. 8. Act of state. 9. Judicial or quasi-judicial acts. Libel and slander. The wrong of defamation is of two kinds, libel and slander. A libel is a defamatory statement which is addressed to the eye and is in permanent and visible form. For example, writing, picture, printing, caricature, effigy, statute, or cinematography. A slander is the publication of a defamatory statement in some transient form, whether visible or audible, for example, spoken words or gestures. However, in the present-day environment, it has become difficult to determine that whether a certain defamatory statement is a libel or slander. For example, the defamatory matter recorded on a gramophone disc is addressed to the ear and not to the eye, and it is a libel because it is in permanent form. Libel is, however, actionable per se, that is, without the proof of special damage, whereas slander is actionable only on proof of special damage. There are certain exceptions where slander is actionable. 1. Imputation of criminal offense to the plaintiff. 2. Imputation of a contagious disease to the plaintiff, which has the effect of preventing others from associating with the plaintiff. 3. Imputation that a person is incompetent, dishonest, or unfit for any assigned job, office, profession, and so on. 4. Imputation of adultery or unchastity. Difference between libel and slander. First, on the basis of nature. Libel, the defamatory matter, is in some permanent form. For example, effigy, written articles, printing, picture, caricatures, etc. It is addressed to the eye, whereas in slander, defamatory matter is in some transient form. For example, gestures, gossips, rumors. It is addressed to the ear. Second, on the basis of position in English law. Libel is criminal offense as well as a civil wrong, whereas slander is a civil wrong only. Third, on the basis of proof of special damage. Libel is actionable per se, whereas slander is actionable on the proof of special damage. Fourth, on the basis of innocence. In libel, the speaker may not be innocent, whereas in slander the speaker is not innocent. Fifth, on the basis of breach of peace. Libel conduces to a breach of peace, whereas slander is not so serious in consequence. No-fault liability, strict and absolute liability. Difference between Ryland's rule and N.C. Metha's rule. First, on the basis of conditions. The Ryland's rule requires 3 conditions for its application. They are dangerous thing, escape, and non-natural use of land, whereas the N.C. Metha's rule is not dependent on these conditions. However, it deals with dangerous things. Second, on the basis of escape of thing from the premises. The Ryland's rule does not cover the cases where harm is caused to persons within the premises, as the rule requires escape of thing, which causes harm, from the premises, whereas the escape of thing from the premises is not a necessary condition, for on the basis of as no distinction is made between persons within the premises, where the enterprise is carried on, and persons outside the premises. Third, on the basis of liability. The liability of the person according to the Ryland's rule is not absolute, as it is subject to many exceptions, for example, act of third party, vis major, etc. The liability is not dependent on the negligence on the part of the defendant. It is called the rule of strict liability, whereas in N.C. Metha's rule the owner of the industry would be liable even if the damage is caused due to the act of a stranger. N.C. Metha's rule provides for absolute liability, and not only strict liability. It is not subject to any exception. It provides for stricter than strict liability. It is called the rule of absolute liability. Fourth, on the basis of exceptions. Ryland's rule is subjected to many exceptions such as plaintiff's own act, act of stranger, statutory authority, act of God, and the act with the consent of plaintiff, whereas MC Meta's rule is not subjected to any exception. Fifth, on the basis of damages. Damages awarded under Ryland's rule are ordinary or compensatory, whereas under MC Meta's rule the court can award exemplary damages. The quantum of compensation depends upon the size of the enterprise. The larger the enterprise, the greater would be the amount of compensation payable. The words are not on the face of them defamatory, or where the imputation is made in an oblique way, or by way of question or exclamation or conjecture or irony innuendo, is necessary. When the words are not prima facie defamatory but innocent, the pleading of the plaintiff should contain the defamatory statement which the plaintiff attributes to it. Such a statement given by the plaintiff is called a innuendo. Thus, sometimes the statement may prima facie be innocent, but because of some latent or secondary meaning, it may be considered to be defamatory. When the natural and ordinary meaning is not defamatory, but the plaintiff wants to bring an action for defamation, he must prove the latent or secondary meaning that is innuendo, which makes the statement defamatory. For example, X published a statement that Mrs. Y had given birth to a child. Here, the statement in its natural meaning is not defamatory. But it may become defamatory in certain circumstances, that is when Mrs. Y pleads that she was married only 2 months ago. These particular or additional circumstances in her pleadings is called innuendo. When the innuendo is proved by the plaintiff, the words which are not defamatory in the ordinary sense may become defamatory, and the defendant will be liable. A case worth mentioning on this point is that of Cassidy versus Daily Mirror. The defendants published in a newspaper a photograph of Mr. M and Miss C, together with the words, Mr. M, the racehorse owner, and Miss C, whose engagement has been announced. This statement was false as they were already married. In an action by the plaintiff, the wife of Mr. M, it was held by the court that the publication was capable of conveying a meaning defamatory of the plaintiff, viz., that she was not the lawful wife of Mr. M and was living with him in immoral cohabitation. The defendants, therefore, held liable. Assault and battery. Trespass to person. Assault and battery are two forms of trespass to person. Battery is the intentional application of force to another person. Assault is an action of the defendant, which causes to the plaintiff a reasonable apprehension of the infliction of a battery on him by the defendant. Winfield. To throw water at a person is assault. It is battery if a drop falls on him. Pulling away the chair when a person is about to sit is assault. It becomes battery when he touches the ground. Similarly, flashing light with a mirror is assault. It is battery when the rays impinge on the plaintiff. The word force has a defined scope in the context of assault and battery. Infliction of light, heat, electricity, gas, odor, and similar things which may be applied to such a degree as to cause injury or personal discomfort, amounts to force as required in battery. As Chief Justice Holt rightly said, the least touching of another in anger is battery, Cole v. Turner. Hence spitting a man on his face is assault, but if any drops fall on him, it is battery. Pointing a loaded pistol is assault. Pointing an unloaded pistol is no assault. In R.V. St. George, it was held that pointing an unloaded pistol at dangerously close quarters was assault. There was a reasonable apprehension of the impact of the gun. Hence it was assault. In Stevens v. Myers P. as chairman, was in a meeting. D. A member became angry and vociferous. Resolution was passed to remove him from the meeting. Thereupon D moved with closed fist towards the chairman, but was stopped by a person who was sitting next to D. Held that there was assault. When a person standing on a railway platform shows his fist to the plaintiff who is in moving train, there is no assault. Class is going on, is battery. But if the teacher wakes him up, there is no battery. Similarly, in the case of sermons, to touch a person with the least force, to call attention, is no battery, if this is done by the bishop. There are hundreds of instances of assault and battery in the day-to-day affairs of human beings. But because of the good humor of mankind, they do not go to the courts. Perhaps the other reason is to minimize non curat lex, meaning law does not take cognizance of trifles. Defenses. For assault and battery, the following are the defenses open to the defendant. I. Self-defense. This is a natural right recognized by law. A person may defend his person, his family, or his property from any trespass. Of course, the physical defense must be proportionate to the injury received. Similarly, a person may inflict injury to defend his property. 2. Right to expulsion. The defendant is entitled to forcibly expel the trespasser who enters by force or otherwise without permission. Of course, the defendant should not use more force than what is necessary. 3. Right to retake property. Use of force as is necessary under the circumstances is valid, and law allows the retaining of the land or goods using force. 4. Valenti non fit injuria. In lawful games like cricket, football, boxing, etc., any injury received is covered under valenti non fit injuria. This is a good defense to the defendant. V. Legal arrest or search. Under the law, the police officer is empowered to arrest a person or search a premises, and in such a circumstance, he may use so much of the force as is necessary according to law. 4. Force used under authority. Parents, guardians, supervisors of trainees, captain of ship, etc., have some inherent rights to correct the persons under their control. Such persons may validly defend themselves, provided the force used was reasonable and necessary. Vicarious liability. Origin and meaning. This concept makes one man liable for the acts of another because of certain relationships like master and servant, parent and children, etc. Originally it came from quid facit per alienum facit per se. He who does an act through the instrumentality of another does it himself. This rule was inadequate to explain the reason. Later the general command theory was put forward, and then particular command theory. None of these was satisfactory, and the modern theory is that the master is liable because he is a substantial fellow or authority. As Winfield points out, this theory is based on social convenience and rough justice. Servant and independent contractor distinguished. The servant is a person who works according to the instructions of the master. The master can not only order him to do an act, but can also control how it should be done. The servant works under the thumb of the master. The master has full powers to control the acts of the servant. He has the powers of removal. Also, he is different from an independent contractor who undertakes to do a piece of job according to the requirements of the employer. The independent contractor is not under the control of employer. Hence, the employer is not liable for the acts of the independent contractor. Liability of the master. The master is liable for the acts of the servant. If the acts are done within the course of his employment, otherwise, he will not be liable. Within the course of employment means I. Doing an authorized act. 2. Doing an authorized act in an unauthorized manner. And 3. Doing acts which are incidental thereto. The act of the servant must fall into any one of the above. Then only the master becomes liable. Broadly speaking, the master is liable for carelessness, mistake, and willful wrongdoing of the servant. Sometimes he is liable for the criminal acts of the servant. Carelessness of the servant. This is the most common kind of wrong, which is generally due to the negligence of the servant. The intention of the servant is not material. If the servant is acting in the course of his employment, then the master becomes liable. But if the servant is on a frolic of his own, then the master is not liable. The leading case is Century Insurance Company v. Northern Ireland Road Transport. In this case, the driver of a petrol lorry was transferring petrol from the lorry to the tank. He negligently struck a match to light a cigarette and threw it on the floor. This caused a conflagration and an explosion. The property of P was damaged. The defendant master was held liable for the careless act of the driver, as the act had been done in the course of his employment. Lighting a cigarette was an act of the servant for his comfort and convenience. The act was innocent, but was a negligent act of the servant, and hence the master was liable. Mistake of the servant. Here the servant is a misguided enthusiast. The leading case is Bailey v. Manchester Railway. The porter of the defendant railway company violently pulled out from a train P, who had a ticket to go to some destination. In fact, the porter had mistakenly taken P to be going in a wrong train. P sued, and the railway authority master was held liable. In another case, the servant of D suspected that sugar was pilfered by a boy from the wagon, and he struck the boy, who fell, and a wheel of the wagon went over his foot. D was held liable. In another case, a petrol bunk servant, under a mistake as to payment, assaulted a car owner P, who had taken petrol. The servant did not know that P had already paid for the petrol. The master was held liable for the act of the servant. Willful wrong of the servant. Here there are two rules. I. The act of servant is still in the course of employment, even if it is forbidden by the master. 2. It is not outside his employment if he intends to benefit himself, though not his master. Limpus v. London General Omnibus Company. The driver had printed instructions not to race with or obstruct other buses. The driver did not observe this, and caused a collision. His master was held liable because this was an unauthorized manner of doing an authorized act. The Beard v. London Omnibus. The driver brought the bus to a terminus and went out for breakfast. In the meanwhile, the conductor drove the bus for the next journey. In so doing, he dashed against and caused injury to P. P sued. It was held that the master was not liable, as the conductor was not in the course of employment when he was driving the bus. In another case, the driver had printed instructions not to give lift to any unauthorized person. The driver violated it, gave lift to P, and there was a collision resulting in the death of P. It was held that the master was not liable for the act of the driver. In Lloyd's case, D was a firm of solicitors. It had employed a clerk to do its work. P, a widow, was the owner of some cottages. She went for professional advice, and the clerk asked her to execute documents, which she did. Here he had conveyed cottages to himself. The court held that D, the master, was liable for the willful wrongdoing of the servant clerk. Criminal acts of the servant. The general rule is that only in some cases master is liable. In Morris v. Martin, P gave her fur coat for dry cleaning to X, who handed it over to D. The servant of D sold it away. It was held that under the circumstances D was liable for the criminal act of the servant. The master is not liable except in some cases where the act amounts to fraud or theft or assault. Independent contractor. An independent contractor is a person appointed by the employer to turn out a piece of job. He is different from a servant in as much as a servant is a person who works under the control and supervision of the master. For the acts of independent contractor, the general rule is that the employer is not liable. There are a number of exceptions. These are the non-delegable duties. According to Winfield, the question is always whether the damage is caused due to the employer's breach of duty. The duties of the employer are divided into delegable and non-delegable. This means the non-delegable functions must be performed by the employer himself. But if he delegates such a function to an independent contractor, the employer himself becomes liable. There are a number of non-delegable duties. Delegation may be a breach of duty itself, and the employer may be negligent in giving instructions or information to the independent contractor. In a case, a gas company had no authority to interfere on the highways. Independent contractor's servant negligently left a heap of stone over which the plaintiff fell and was injured. Held, the employer was liable. Ellis v. S. G. Company. 2. Obligations of the employer are to provide a competent staff of men, adequate material, and a proper system of effective supervisor. If he does not follow these, the employer becomes liable. 3. Operations on or adjoining the highways. In Tari v. Ashton, there was an overhanging lamp of D on the footway. D appointed independent contractor to repair who did it negligently. The lamp fell on a passerby. It was held that the employer D was liable. In Gray v. Pullen, the defendant D had statutory authority to make a drain from his house to a sewer across the road. He appointed independent contractor to cut trenches, who did it but negligently filled it up. The plaintiff a passenger was injured. D was held liable. 4. Case of strict liability. The rule in Ryland v. Fletcher is applicable in respect of bringing and storing of items which cause injury when they escape. In such case, the employer is liable. V. Cases of statutory authority. The recent enactments have fixed the liability of the employer under the Factories Act, Workmen's Compensation Act, etc. In Padbury's case, D employed a subcontractor to put casements to the windows. In soap putting, an iron tool which had been kept by the servant on the windowsill fell and injured P on the street. P sued D. The court held that D was not liable, as the tool was not placed in the ordinary course of doing work. There was only a collateral negligence of D. 6. When the employer personally interferes and gives directions to the independent contractor, the employer becomes personally liable. Joint tortfeasors. When two or more breaches of legal duty by different persons result in a single injury to the plaintiff P, then the two or more persons are called joint tortfeasors. According to Lord Justice Bankers, persons are said to be joint tortfeasors when their shares in the commission of tort are in furtherance of a common design. In Brooke v. Boole, two men were searching for a gas leak. Each applied naked light to the gas pipe in turn, and one of them caused explosion. They were held to be joint tortfeasors. This is different from a case where two ships negligently collided and later dashed against another vessel negligently. This is also different from a tort committed by a child under the directions given by the parents. Contribution. Both the joint tortfeasors are liable in tort, but the plaintiff can claim the amount in full from one of them. Question arises in such cases whether one tortfeasor may claim indemnification from the other. In Merriweather v. Nixon, A and B jointly damaged the machinery in C's mill. C sued them jointly and got compensation which he recovered from A. Now A sued B for half the amount which he had paid. It was held that A could not recover from B. This decision has been reversed by the Parliament in England in the Law Reforms Act 1935. According to this, one tortfeasor can recover his contribution from the other tortfeasor. Hence, he is entitled to be indemnified. No-fault liability, strict and absolute liability. Difference between Ryland's rule and N.C. Metha's rule. First, on the basis of conditions. The Ryland's rule requires 3 conditions for its application. They are dangerous thing, escape, and non-natural use of land, whereas the N.C. Metha's rule is not dependent on these conditions. However, it deals with dangerous things. Second, on the basis of escape of thing from the premises. The Ryland's rule does not cover the cases where harm is caused to persons within the premises, as the rule requires escape of thing, which causes harm, from the premises, whereas the escape of thing from the premises is not a necessary condition, for on the basis of as no distinction is made between persons within the premises, where the enterprise is carried on, and persons outside the premises. Third, on the basis of liability. The liability of the person according to the Ryland's rule is not absolute, as it is subject to many exceptions, for example, act of third party, this major, etc. The liability is not dependent on the negligence on the part of the defendant. It is called the rule of strict liability, whereas in N.C. Metha's rule the owner of the industry would be liable even if the damage is caused due to the act of a stranger. N.C. Metha's rule provides for absolute liability, and not only strict liability. It is not subject to any exception. It provides for stricter than strict liability. It is called the rule of absolute liability. Fourth, on the basis of exceptions. Ryland's rule is subjected to many exceptions, such as plaintiff's own act, act of stranger, statutory authority, act of God, and the act with the consent of plaintiff, whereas N.C. Metha's rule is not subjected to any exception. Fifth, on the basis of damages. Damages awarded under Ryland's rule are ordinary or compensatory, whereas under N.C. Metha's rule the court can award exemplary damages. The quantum of compensation depends upon the size of the enterprise. The larger the enterprise, the greater would be the amount of compensation payable.